human being. I am not a fictitious person. I am not a corporation. And therefore, I'm an attorney in fact. I'm holding due court. And I accept the charge of value. And I want to use my UCC financial statement, my number, to write this charge off.
Do you plead guilty, not guilty, or no contest?
I don't believe in that. I mean, come here with you. I can't do business. It is court that business been done.
All right, well, I'll enter a not guilty plea on your behalf in CF 2016-15738. I'm not really sure what the UCC has to do at this point in time with these charges or your answer, Mr.
Markeith Loyd in all capital, that's not me. That's a corporation that was created at my birth that I do not accept. That's not me.
With respect to the charges in 2017, CF 826 of first-degree murder in count 1, attempted first-degree murder with a firearm in count 2, aggravated assault with a deadly weapon in count 3, carjacking with a firearm in count 4, and possession of a firearm by a convicted felon. How do you plead to those charges, sir? All right. So I'm going to enter not guilty.
For the record, do anyone have a claim? Do you have a claim? Do you have a claim against me? Did you state your name for the record?
Well, my name's right there on the it's Fred Lawton. I'm a circuit court judge. And
do you have a claim against me in this court?
well, I don't bring claims. The state of Florida, Mr. Loyd, listen to me for a minute. The state of Florida has, Mr. Loyd, listen, don't answer that yet. Mr. Loyd, listen to me. The state of Florida has charged you with these offenses, not the court, the state of Florida. And the state of Florida is represented in court today by the state attorney's office. The state of Florida is a corporate entity, and they're represented by the state attorney's office.
When you check the Black Law Dictionary, you look at the word person, which I am not the person that y'all talk about. It's a fictitious person. It's a fictitious person in a corporation, which is not me. It was created in my birth by the slave system. That's not me.
Well,
I'm a flesh and blood person. Y'all have jurisdiction over me.
based on that answer, Mr. Loyd, I'm going to enter a not guilty plea on your behalf to both of the indictments that have been returned against you. And I want to talk to you now about whether you desire to represent yourself or have counsel appointed to represent you to defend you on these charges. So do you want me to appoint counsel to represent you?
No.
All right, so let's go through this inquiry again, which is going to take a little bit of time, but I need you to respond to me as I ask you these questions. Pardon me?
What's the inquiry?
The inquiry is about, under Ferretta, whether you are capable of intelligently making the choice, not representing yourself to the same degree of competency that a lawyer would, but whether you're able to make this choice, and I'm required to go through this with you, so I'm going to do it now. Do you understand, Mr. Loyd, that you have the right to have an attorney appointed to represent you? That you possess that right? Yes or no, sir?
Yes, I have a constitutional right, so I'm representing myself, so what's that talk about?
We're talking about your choice, the decision that you've made. So I'm going to ask you these questions and ask you to answer them. And as I mentioned earlier, if you choose to represent yourself, you and I have to communicate. And so there are some answers to questions that I need from you. If you decide not to communicate with the court, then I may appoint an attorney to represent you. Even if you don't want an attorney to represent you, that could be the result, because in choosing to represent yourself, we have to communicate with one another. So do you understand that if you can't afford to hire an attorney, if it's a financial decision, that one would be appointed for you at no cost to you? Do you understand that, Mr. Loyd?
Who has a claim? I want to state of Florida. What state of Florida understand? So I can talk to the state of Florida.
Let's stay focused on my inquiry for now. Do you understand that if you could?
The people know what's really going on in these courtrooms in this country, period.
Do you understand that if you can't afford to hire an attorney, one would be appointed to represent you?
I might have a right to raise my accused. What's the state of Florida?
Well, you keep wanting to go there. I want to talk to you about appointment of counsel, and then we'll. Do you understand that if you can't afford to hire an attorney, one would be appointed to represent you? Do you refuse to answer that question, sir? Mr. Loyd, I want to explain to you some of the ways that a lawyer representing you in this matter would be to your advantage. A lawyer's legal knowledge and experience may favorably affect all pretrial decisions in your case. A lawyer's experience and knowledge would result in obtaining information about the case through the use of discovery, which will be limited to you because you're in custody. They might uncover potential violations of constitutional rights and take effective means to address them. A lawyer could ensure compliance with speedy trial and statutes of limitations. They may identify and secure favorable evidence to be introduced at your trial on your behalf. A lawyer has the experience and knowledge of the entire trial process. He or she could argue for your side during the whole trial and present the best legal argument for your defense. Since jury selection and qualifications are governed by numerous legal procedures, a lawyer's knowledge and experience may enhance the selection process on your behalf. A lawyer can call witnesses for you.
I don't care about, I'm representing myself. It ain't nothing y'all can do, nothing this courtroom can do. Worst thing that happened than already happened in my life. So other than that, I'm representing myself. I don't care about it.
Well, I want to talk to you about this.
If I'm trying to put a service on for the media, y'all can say that I don't care about it.
Let me go.
Y'all can't do nothing to it.
Let me go through this with you, Mr. Loyd, and then I'll ask you some questions, and I'll take your answer, and then I'll decide what to do with your answers. A lawyer can call witnesses for you, question witnesses against you, present evidence on your behalf. A lawyer can advise you whether or not you should testify, the consequences of that decision, what you have a right not to say. A lawyer has studied the rules of evidence and trial procedure and knows what evidence can be admitted and what evidence cannot come into your trial. A lawyer may provide assistance in ensuring that the jury is given a complete and accurate jury instructions by the court as it pertains to this matter, may make effective closing arguments on your behalf, may prevent improper arguments by the prosecutor. A lawyer may ensure that any errors committed during trial are properly preserved for appellate review by a higher court. If you are convicted, a lawyer's assistance may be useful in preparing for sentencing, ensuring that favorable facts are brought to the attention of the court, ensuring that the court is advised of all legally favorable dispositions, and ensuring that the sentence is lawfully imposed. An attorney's legal knowledge and experience may be useful in filing an appeal and in seeking appellate remedies from the appellate court. Mr. Loyd, as it is almost always unwise to represent yourself, let me tell you some of the disadvantages of representing yourself in court. Mr. Loyd, do you understand that you will not get any special treatment from the court just because you are representing yourself? Do you understand that, sir? Do you understand that you'll not be entitled to a continuance simply because you wish to represent yourself? Do you understand that, Mr. Loyd?
You understand that y'all can't do nothing to me. That's all you do. Just go kill me, strap me up right now. I don't care nothing about y'all. The worst thing that happened happened. I don't want that shit you talk about. I don't give a fuck. I don't care nothing about that. The worst thing that happened to me. I'm gonna represent myself. So what you keep going through, trying to put on for the media, say, oh,
Mr. Loyd.
And make up stories and shit. Come on.
Mr. Loyd, we talked about this a little earlier. First of all, if you desire to represent yourself, you have to follow the rules of procedure and decorum in a courtroom. So that if you want to represent yourself, you have to follow those rules.
Be confident, which I am, which you have already established that. You've been already been there from the first time I came, when we had the hearing. Be confident and don't have those mental illness, which I don't. I don't have no all.
It's beyond that, Mr. Loyd. It's also, can you follow the rules of procedure and decorum in the courtroom? And I'm also obligated, whether you want to hear this or not, for me to advise you of some disadvantages that you face by representing yourself. For example, you're in custody, and so you are limited in the legal resources that are available to you while you're in custody. And you won't be entitled to any additional library privileges just because you're representing yourself, and a lawyer would have none of those restrictions as to both legal research and factual research, and could fully research your case. So you are at a disadvantage in that situation. Do you understand that? All right, sir. You're not required to possess the legal skill or the legal training of an attorney in order to represent yourself, but you will, as I just mentioned, be required to abide by the rules of criminal law and the rules of courtroom procedure. These laws took lawyers years to study and learn, and if you demonstrate an unwillingness to abide by these rules, then I might terminate your right to self-representation. Do you understand that if you're disruptive in the courtroom, that the court can terminate this choice that you want to make of self-representation, either appoint counsel to represent you or ultimately even remove you from the courtroom, in which case your matter would be tried without your being present? Do you understand that your access to the state attorneys who are prosecuting the case will be severely reduced as compared to a lawyer who could contact them freely? Do you understand all of that, sir?
I'm here to tell what happened, tell my story, however they see it, however y'all see it, y'all do what y'all want to do here. I'm here to tell the truth. Other than that, I don't care about nothing. I'm none of that stuff.
Mr. Loyd, do you understand that the state won't go easier on you or give you any special treatment as just because you're representing yourself, and they'll present their case to the jury as if they had an experienced trial lawyer on the other side? Finally, Mr. Loyd, and most importantly, if you're convicted, you cannot claim that your own lack of legal knowledge and skill constitutes a basis for a new trial. In other words, you can't claim that you received ineffective assistance of counsel. Do you understand that, sir? Yes or no, sir?
Yes.
All right. Do you understand that there are dangers and disadvantages to representing yourself? Do you understand what I just read to you, sir?
Keep going on with the same old stuff. We got to get this ball.
I indicated to you earlier that we have to go. Let me talk for a minute, Mr. Loyd. I indicated to you earlier that I have to go through this with you multiple times, and so it does require some patience on your part. And so I'm required by law to cover this with you. And I know you don't have legal training, but you have to accept that I'm required by law to talk to you about this, whether you like it or not. And so that's what I'm going to do. In this area about the fact that you may be disadvantaged by representing yourself, do you have any questions for me? Any questions in this area of the law, Mr. Loyd? No? Okay. Mr. Loyd, I think you've received and been given possession of the charges that have been filed against you. Do you have the indictments? Do you have those? Have you reviewed those? All right. Do you have any questions about the charges that have been filed against you? Do you understand those charges? Not whether you agree with them, it's just do you understand the charges that you're facing? Do you have any questions about what you're charged with in terms of the charges you face? All right. Do you understand the penalties that accompany these charges, which we reviewed the last time that we were together? Any questions about the penalties that you face, Mr. Loyd? All right. And if you're found guilty in counts 1 and 2 in 2017 826, then you face the death penalty as a possible penalty. In count 3, you face 5 years in prison. In count 4, you face a possible life sentence. And in count 5, you face a 15-year maximum sentence with the 3-year mandatory minimum. In 2016 CF 15738, in counts 1 and 2, you face the possibility of death as a penalty. In count 3, you face the possibility of life in prison with a 25-year mandatory minimum. In count 4, you face the possibility of life in prison with a 20-year mandatory minimum, and that's also true in count 5. And in count 6, you face a 15-year maximum penalty with a 3-year mandatory minimum. You understand, Mr. Loyd, that if you're not a citizen of the United States and you're found guilty, you could be deported from this country. I don't think that applies to you, but do you understand that? Let's go through these questions and answer one more time for me. And I know I asked you these before, but if you'll just tell me one more time. Mr. Loyd, how old are you again? How old are you, Mr. Loyd? Mr. Loyd, if you want to represent yourself, you have to communicate with me. And that question is, you should be able to answer. How old are you, sir? I know, I'm asking you again. How old are you? All right, you don't know how old you are? Well, my question's pretty straightforward, Mr. Loyd. How old are you? Because I'm required to ask you this. Would you tell me, please, sir, how old are you? Mr. Loyd, can you read and write? Do you have any difficulty with the English language? How many years did you complete in school? Was it 10th grade? Is that what you told me? All right, thank you. Have you ever been diagnosed or treated for a mental illness? Are you currently under the influence of any kind of drugs or alcohol? Mr. Loyd, do you have any physical condition that would limit your ability to defend yourself on these charges? Let's talk a little bit about your eyesight, because I noticed that you're wearing an eye patch over one of your eyes. So can you see out of the other eye? All right. If you're given a document to read, can you read that document? All right.
I could affect that eye, but I don't know what it is.
Has anyone threatened you if you hire a lawyer? All right, thank you, sir. Mr. Loyd, have you ever represented yourself in trial before? Do you have any questions? Is there any question in your mind about this appointment of counsel? Anything I haven't covered for you? Or is there anything about the appointment of an attorney that you want to ask me about? Okay. All right, Mr. Loyd, I know that this required some patience, but let me ask you this. Having discussed with you the right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of these charges and the possible penalties, in the event of a conviction, are you certain that you do not want me to appoint an attorney to defend you? All right. Mr. Loyd, if I allow you to represent yourself, and if you requested, I could have the assistant public defender act as standby counsel. You would be in charge of your case. You would make the decisions. This lawyer would just be available to you if you have questions in the course of the proceeding so that you could consult with that attorney. But it would be your right and your obligation to present your own defense and to act as your own lawyer. They'd just be a resource to you. Do you want me to appoint standby counsel for you? Do you understand what that is? Do you have any questions about it? They would just be here in this courtroom and able to assist you if you felt you needed assistance and you wanted to talk to them in the course of the trial without them acting fully as your lawyer. Any questions about that, Mr. Loyd? I'm considering doing this no matter what, so that they could be here and assist you in case you got to a point where you said to me, for example, Judge, I'm confused about this legal proceeding. If I could just talk to somebody and get some advice, then I could make some decisions. And so, do you have any objection if I appoint standby counsel for you?
I don't want to set up on this court because I know stuff for real long for a reason. I don't want to set that. I got stuff that I don't want to set. Because I'm not the person. I'm not a fictitious entity. I'm not the operation. In the Black's Law Dictionary, person will tell you a person meaning, which that is not me. That was created in my birth through the slave system. The government created their name, Markeith Loyd in all capital letters. That is not me. And in court law, corporation on the bill with corporation, that's why it's a state of corporation. Markeith Loyd in all capital letters. There's two corporations. That's not me. I'm a flesh and blood person.
All right, I'm going to make the following findings of fact. Mr. Loyd is 41 years of age, which was, I found the answer to that question from our first meeting. He completed 10 years of school. He indicates he has his GED. He's never represented himself before. He's not under the influence of alcohol or substance abuse. He can read and write in English. He's never been diagnosed that he knows of with a mental illness. He has some issues with respect to vision, but he can read and write and see. For the record, Mr. Loyd wants to talk about the UCC and corporate status, which is a position that certain citizens that are sometimes called sovereign citizens take in courts of law, oftentimes misguided, but it's not the first time the court's heard that position. Sometimes Mr. Loyd doesn't want to cooperate with the court and answer questions, at other times he does. Verbally, we're having some difficulties, and yet Mr. Loyd is behaving himself in the courtroom. And so the issue, once again, is Mr. Loyd competent to make the decision to waive counsel? Not, as many people misunderstand Feretta, is he competent to act as his own attorney, which is not the inquiry. As I stated earlier, I think it's a bit of a close call, but I think Mr. Loyd is competent to make the decision. My concerns about...
Thank you for listening. In a few seconds, the live stream from WNYC 93.9 FM.
All right, if you will just turn that off or hand it to the deputy, either one. The concerns that I have are that occasionally Mr. Loyd wants to talk about something other than the business that we have to conduct. His wanting to talk about the UCC and his status as a citizen. He doesn't want standby counsel, but I'm going to appoint the Public Defender's Office to act as standby counsel. I'm going to ask them to immediately investigate whether they have any conflicts to act as standby counsel. State, have you made a decision whether or not you will be pursuing the death penalty in these cases?
Your Honor, Deborah Barrow on behalf of the state of Florida, that decision has not been made yet.
Mr. Loyd, if the state chooses to seek death as a penalty in this case, and it's a choice that they're under a time clock to make, and we get to the point where you're convicted, then you have the right to present to the jury in the court what is known as mitigation evidence, or evidence about your life that the jury and the court can consider in deciding what penalty should be imposed. That is, whether death should be the penalty if you're convicted. That's called mitigation evidence. I don't know whether you've heard that term before. It's a little early in the case, although the time is clicking away. Do you have any sense whether you would present mitigation evidence if you were convicted? Let me phrase it a different way. If you were convicted, would you waive the presentation of mitigation evidence? You would present it. You would. Okay. Do you want me to appoint an attorney just on that matter? Just to go out and start to collect evidence about your life that would be presented in mitigation were you to be convicted and the jury to be considering the death penalty? You're going to do that on your own? In other words, you told me you're not going to waive it, so you're going to present it to the jury, but you're going to do that on your own? You don't want a lawyer to help you even with that issue? All right, I'm going to do a little further research about whether I'm going to appoint mitigation counsel, even if because you're not waiving mitigation evidence if that comes up, and I may appoint an attorney to begin to assemble that evidence for the benefit of the court and the benefit of the jury and for your benefit. So let's talk about trial and pretrial dates. State, when does speedy trial run? In 2016 CF 15738.
July 12th of 2017, Your Honor.
And is it the same speedy trial date for 2017 CF 826?
It's roughly the same, Your Honor. I believe he was served with that approximately 3 days after the...
So to be conservative, July 12th.
Yes, sir.
All right. Which case would you prefer to try first?
Your Honor, we haven't made that decision yet. There's a lot of factors that would go into
Well, I'm going
that.
to pick one.
Yes, sir.
Do you have any objection if I pick one?
If
I mean,
it-
I'm likely to try the 2016 case first and then try the 2017 case second.
For right now, Your Honor, that's perfectly fine with the state of Florida.
All right. So I am contemplating a pretrial for the 2016 case of April 17th and a trial date that starts May 1st. And do you have an idea roughly how long you think the case would take to be tried?
The state anticipates we could try case in chief in 3 days at the most.
Okay, so jury selection might take a bit of time.
It does not include jury selection, that's correct, Your Honor.
So if we added a week to that, you think in 2 full weeks the guilt phase would be finished?
Yes.
All right, Mr. Loyd, you want to be heard about the trial date? I'm proposing that we begin jury selection on May 1st, which is going to be here before you know it. And I would set a pretrial of April 17th, and I'm going to set statuses before those events. You want to be heard on the setting of the trial date? Do you want to give me any input, like I would ask an attorney who is representing you, for the setting of the trial, the dates for the trial? All right. All right, so for the moment, I'm going to set pretrial on April 17th at 10 and the trial to start on May 1st. And today is March 1st. I'm going to set a status in this matter on March 20th at 10 o'clock, on April 3rd at 10 o'clock, and then we'll have the pretrial on April 17th. I say this is fairly quick. And then for now, I'll set the 2017 case for pretrial conference on June 12th with a trial date of June 19th. And I'll set status dates that somewhat mirror the others. I'll set a status date on March 20th at 10, April 3rd at 10. At the pretrial conference for the 2016 case, we'll status the 2017 case. We'll have another status on May 31st, and we'll have pretrial on June 12th with a trial date of June 19th. Any questions about those dates?
No, Your Honor.
Mr. Loyd, any questions about those dates? State, any issues you think we need to cover today that we haven't covered already?
No, Your Honor.
Mr. Loyd, anything you want to bring to my attention today that we haven't covered? Do you have any questions about what we've covered today or where we are? For the record, you're shaking your head no. Okay. And then Our plans then, Mr. Lloyd, are that I'll see you for a status about 19 days from now on March 20th at 10, where we'll talk about the status of the upcoming trial. Any questions about what that's all about? And then in the meantime, I'm going to do some research about possibly appointing an attorney to conduct mitigation evidence. I'm going to ask the Public Defender's Office to indicate to the court within the next 5 working days, if it's able to do so in that time period, whether it has any conflicts as acting as standby counsel for Mr. Lloyd, because I'm appointing them to do that at this time. And I think that's it. But once again, if there's anything else, let me know. No? Okay. Thank you very much, everyone. We're in recess.